Hi, Miko. Thanks for joining us. Before we start, can you introduce yourself to our audience?
All right. So, hi everyone. I am Miko. I am the in-house legal counsel of Founders Launchpad. So, basically, I do the legal works in Founders Launchpad. If they needed like legal advisory or legal consulting, and also contract review and preparation, and also ensure that everything is in compliance with the law. So, I am the person for that.
Nice. So, basically, we're doing this video because a lot of our founders usually have resources on the business side of things, but it's very hard to navigate on establishing a business here in the Philippines. So, I wanted to ask, what do they need to do if a founder wants to start building here in the Philippines?
Okay, so if a founder wants to start his startup here in the Philippines, of course, apart from all the business models, apart from all how to make money, on the legal side, of course, the founder has to think of which type of business organization he wants for his startup.
Okay.
So in the Philippines, we have three types of business organization. The first one is single proprietorship, second is partnership, and third one is corporation. So if the founder wants his business in his name, he wants to have like 100% control or ownership and management of his startup, and he is also willing to take the risk and obligations all by himself, then definitely he may choose or he may consider putting up a single proprietorship.
Okay.
Now, if he has a co-founder or co-founder or co-founders,
Yeah.
so they all gather their resources, they all pool their money, even their skills, and in their startup, and they wanted to also, or they are also willing to share the risk and wanted to divide like the profits for themselves. So they may consider putting up a partnership.
Okay.
But one thing they have to note, also for single proprietorship or sole proprietorship, both in sole proprietorship and partnership, the liability extends to the personal property of the partners or of the sole proprietor.
Okay.
Now, if the founder or the co-founders are wanted to have their startup or wanted to have their company having a separate personality, or having it can stand on their own, they can own property. The company can own property. They can do business transactions. They might consider, or they may want to consider putting up a corporation. But in a corporation, of course, the ownership only extends to the number of shares that they own. So it's not fully 100% owned, depending of course if you have like co-founders, if you have like investors coming in. So the evidence of ownership for corporation would be the shares of stock. But the good thing about the corporation is that the liability or the obligation only is limited to the corporation itself. So there's a separate personality between the corporation and the stockholders. So whatever the liability of the corporation, it will only be the liability of the corporation, but not of the stockholders in their personal capacity. So those are the three types of business organization that they may want to consider putting up. And once that they already decided which one they want, they may already start registering their business. So yeah, if they wanted to start a sole proprietorship, then they should register with the Department of Trade and Industry.
Okay.
But for partnership and corporation, they need to register it with the Securities and Exchange Commission.
Okay. But if in any case you're a foreigner in the Philippines, is there any extra steps they need to take to establish this?
Okay, so if you are a foreigner founder and you want to build your startup here in the Philippines, one thing that you have to consider is that in the Philippines, we have a law called the Foreign Investment Act.
Right.
So basically, it regulates the foreign investment here in the Philippines and the foreign ownership. And under the Foreign Investment Act, so we have this list. It's called the Foreign Investment Negative List.
Okay.
So in this list, it enumerated the industries with foreign ownership restrictions. So for example, if you look at the list, then you would see which industries prohibits foreign ownership or which allows like 25% or 40% foreign ownership. So for example, like if you wanted to be engaged in mass media industry, or you want to practice your profession, or you want to be in retail, but your capital is specifically for retail, if your capital is less than 25 million pesos, under the foreign investment negative list, there should be no foreign equity for that.
Okay.
But there are also other industries which you can be in.
And then,
But if you just check the foreign investment negative list, you will see like how many percentage that you can own. So it's also one thing that if you have Filipino co-founders, it's one thing that you have to discuss with him, and also another thing to discuss with your investor, because definitely you wouldn't have the same equity, or you wouldn't have the same percentage of ownership if your startup is under these industries which with foreign ownership restrictions. But if your startup or your company does not belong to any of those industries in the list, then definitely you can own 100% of it. But the only thing is there's a minimum foreign investment capitalization or foreign investment amount of $200,000 US dollars.
okay. So let's say you're a founder and you already incorporated here in the Philippines. Can the startup already start operating actually?
So after you incorporated your company, for example, if you're a corporation, you register your business with the Securities and Exchange Commission. It doesn't stop there. You still need to register with different government agencies.
Okay.
So first, after incorporation, you need to register with the Bureau of Internal Revenue. So of course, you have to pay your taxes. So you have to get your tax identification number. You get your certificate of registration with the BIR. And then, of course, apart from that, you also need to get your authority to print for you to be able to issue invoices. And that will be, you can use that in your transactions.
Right.
And then if you intend to employ or if you intend to hire employees, then there will be additional registration that you need to go through.
Okay.
So you need to, if you have employees, then you need to register with the Department of Labor and Employment.
Okay.
And also you have to give them like the government mandatory benefits. So for that, you need to be registered with the Social Security System,
Okay.
the Pag-ibig Fund, and also the PhilHealth.
Okay.
And after that, you still have to go another registration. So you still need to register your business to the local government unit where you have your office. So if you incorporate, you will have your articles of incorporation, and it is indicated there where is your primary office, where you have to decide where your primary office is, and you have to put it there. So in the registration for the local government, you need the address that you put in your articles of incorporation, that's where you need to register. So you have to get your business permit there. After you comply with all that registrations, you can already start operating. But that is only like a minimum requirement. If you are engaged in an industry with like a separate regulation that needed additional registrations, then definitely you have to comply with that. So that's those agencies that I mentioned are the basic ones, but you really have to check the regulations, or you really have to consult, for example, for a lawyer, if your industry falls to another industry with a specific or a special registration requirements.
Is there any compliance requirements that these founders need to comply with government offices? Like, let's say they want to avoid penalties. So what are those compliance requirements they need to put on?
Okay, so after you registered your business, with all the agencies that I mentioned earlier, and then you started operating already.
Right.
So you have to maintain your registration to these offices.
Okay.
So first with the SEC, with the Securities and Exchange Commission. So you have to file your annual general information sheet. So in the general information sheet, it contains the details about your company and also the details of the shareholdings. And also with the SEC, you need to file your annual financial statements.
Okay.
Now with the BIR, of course, there's in your transactions there will be taxes, right? So in your certificate of registration, it's already listed there like what are the taxes that you needed to pay.
Okay.
And also the time that you need to pay it.
Okay.
So there will be there are some taxes that needed to be paid monthly. There's some taxes that you need to pay quarterly and annually. So what you just need to do is to check your certificate of registration and then comply with all the tax filings and also tax payments. And then for the mandatory benefits for your employees, so for SSS, Pag-ibig, and PhilHealth, you have to remit the payments to these government agencies. So every month, there's like an equivalent monthly contribution for the employees. So the cost is actually shared between the employer and the employees, but it's the employer's duty to deduct it from the employee's salary and pay the employer share and remit it to the respective government agencies.
Okay.
And then for the local government unit, apart from the taxes with the BIR, then there's also a separate local government tax that you need to pay to maintain your business permit.
Right. Okay.
So yeah.
So we notice a lot of the founders here in the Philippines, they actually become incorporated in Singapore. So why is that the case for most of the founders here?
Well, in general, I mean, not considering or not thinking first about the place. So if you are a founder, you want to put up your business in a place where it will be easy for you. So some of the factors that you need to consider is without first thinking about the country. So some factors that you have to consider first is the ease of incorporation. So which country do you think would be easy for you to incorporate? Because you don't want to spend so much money in paying these registration fees, but still you can't operate because there would be so much red tape. There would be a lot of process or a lot of requirements that you need to comply just to put up your corporation. So you wanted to look into which countries you can easily incorporate your business. And then second one, you can also look into the taxes, the rate of taxes that you need to pay like every year or for every transaction. So it's also a good thing to look into a country where there has a low income tax rate or low corporate income tax rate, so that, of course, you can already save with the percentage of tax that you have to pay. So if you go to this country and they have, like, for example, 30% and another country has 15%, of course you have to, I mean, it's the best choice to go through the 15% tax because you can use the other 15% for your operations. And also, I think another factor would be the political stability of the country. So you wouldn't want to go to a country with too much corruption or too much bribery and all that. And I think you want to be in a country where there has good regulations for startup or are really supporting for startups. So it's a consideration that you need to factor in when you decide which country that you wanted to build your startup. And then lastly, of course, there are still other factors, but lastly, I think it would be good to have a strategic location because if you intend to have like investors from all over, you wanted to be in a location where you can be easily accessed. They can easily send their investment money, or you can easily give them their dividends. So those are the 4 factors that you have to consider. Of course, you can consider all other factors, but I think those are the main ones. And I think Singapore ticks all the boxes. So it's easy to incorporate in Singapore, lower income tax compared to the Philippines, and also politically stable and strategically located with all the other countries. And also, I think most of the VCs, most of the investors are also incorporated in Singapore. But one thing that you have to note is that if you are registered in Singapore or you are registered in another country and you want to do business in the Philippines, you cannot do business in the Philippines unless you are registered here. So you still have to go through the incorporation process and all the registrations. And also another thing is that if you are a Filipino founder and you registered your business in Singapore, if you wanted to do business in the Philippines, you have to note that your company in Singapore is considered as foreigner, as non-Filipino. So, as I mentioned earlier, there are certain industries that has foreign ownership restrictions. So, if you wanted to do business in the Philippines under that industry, your Singaporean company cannot 100% own the Philippine company because of that foreign ownership restriction. So what they usually do is that, of course, if you are a Filipino co-founder, you can have the certain equity for the Filipinos, and then the Singaporean entity or the foreign entity can have the remaining. So that's a thing to consider. And also, if the company is foreign owned, then you have to again comply with the minimum investment capital.
Okay, so let's say I'm starting to fundraise and I'm bringing a new investor to our cap table. What exactly do I need to do? And is there any documents that I need to prepare beforehand?
Okay, so let's talk first about if you are a Philippine company.
Yeah.
So if you are a Philippine company and there's an investor coming into your cap table, the first thing that you need to check is if you have enough equity to give. So you need to check your articles of incorporation, because in the Philippines, we have this concept of authorized capital stock. Authorized capital stock. So this is the maximum number of shares that you are allowed to issue based on your charter, based on your articles of incorporation. So you need to check that, and you need to check how much or how many of the authorized capital stock has been subscribed already, or if you still have some shares that is available for issuance. So if you have sufficient shares to issue to your investors, then it's good. But if you don't have, then what you need to do is to amend your articles of incorporation and to increase your authorized capital stock to a number that is sufficient to have enough shares to issue to your investors. Now, regardless if you are a Philippine company or you are a Singaporean company and there's an investor coming into your cap table, usually you need to have an investor's agreement. So an investor's agreement would govern or would lay down the terms and conditions of the investor's investment to your company. And also, once the investor is in your cap table, usually you would need to execute like a shareholders agreement among the shareholders. So the difference between the investors agreement and the shareholders agreement is that the investors agreement only governs the specific investment between the investor and the company, but the shareholders agreement covers the entire shareholders. So if there are also other investors that is already in your cap table, so definitely you would have agreements between among all of them to not only to govern their investments but also to govern the corporate affairs of the company. And also usually they require you to execute a non-disclosure agreement. So it's also important to have that, because you also don't want to have your information become public, because you just work hard to have it, to develop your business models and all that information. So I think those are the primary documents. Of course, there would be other documents, but I think that would be like the primary ones.
Okay. So you mentioned the Investors and Shareholders Agreement. Is there any key points that these founders really need to consider when they're preparing these documents?
All right. So for the Investors Agreement, also for the Shareholders Agreement, I believe that it has to be thorough, because it will involve like a sum of money.
Yeah.
It's not a small amount. Probably be a big amount of money. So usually the investors agreement contained, of course, the investment amount, and then you may want to put like the valuation method on how their investment money would convert into equity, because you may want to, like, how would be the conversion factor from the investment into shares? So how can you value that? So you want, so to avoid confusion, you should also include that in your investors agreement. Also, apart from those, you need to, I think it would be important to put, like, if the investors, or based on your discussion with the investors, do the investors have a seat in the board? So it's also, I think it's part of, it would also be part of your negotiation if the investor wants to be in the board, because there are also some investors that don't want to be in the board, just put the money and maybe earn dividends at some point. But so if the investor wanted to have a board seat, then that's something that you need to discuss, and how many seats that they need. You have to also maybe look into, like, the investment amount. If maybe they would demand like so many board seats, but they only invest a little. So it's something, it's up for discussion, but definitely you need to put that in your investors agreement, like how many seats are they entitled for the board of directors, and also their voting rights. Because, like, if they are part of the board, of course they have to vote on certain matters that the corporation are doing, so they have a say in the corporation. So definitely you have to put that in your investors agreement, like what like, do they have the right to vote in certain matters of your corporate affairs, and or if specific matter that they need to vote on, so something like. And you may also want to include exit strategies, so, or exit clauses, because you don't want to, you want to have this agreement that would govern the entry and the exit, right? So in the exit clauses, usually we put the buyback of shares. So if the company will have the option to buy back the shares of the investor, or also you can put like the tag along or drag along rights. So for tag along rights, usually if a shareholder is selling its shares to a person which is outside of the company, then definitely others can tag along with that shareholder. Or for example, for the drag along rights, if the majority of the shareholder decided to sell the shares to a third party, then they can require the other shareholders to also sell their shares. So that would be an example, or those are the examples of the exit provisions. And well, it sounds simple, but it's you need to thoroughly put the process on how to do that. And also, you may want to put as well anti-dilution provision and some warranties and indemnities in case, like, what are the liabilities of each of the founders or each of the investors. And of course, if there are certain obligations of each parties that you need to, or that you want to be in that investors agreement, then definitely you can put that. And it's also the same with the shareholders agreement. The difference is that the only difference is that in the shareholders agreement, it would be all the shareholders and not only the investor who will execute that.
Okay. You mentioned earlier about having an NDA. So how should these founders keep in mind of what to put in this NDA?
Okay, so for the NDA, or non-disclosure agreement, of course, you have some confidential information that you develop, eventually putting up your business. So what you want to put there, or you may want to define what are those confidential information that you want to protect. So you can make it as comprehensive as you can, so that all the confidential information will be covered. And also, you may include there the terms of the the period until when the non-disclosure agreement is effective. But usually, well, you can put the term, but usually what I do is that the confidentiality or the confidentiality obligation of the parties will survive the termination of the agreement, except of course if the confidential information becomes public without the fault of the parties in the NDA. So of course there has to be a specific term, but the obligation to keep the information confidential should survive the termination of the agreement. And also, you may also want to put like what are the remedies in case of breach of these non-confidentiality obligations. What are the remedies that the disclosing party or the person disclosing the information has? So usually they can claim for damages, or they can get like an injunctive order from the court, and also of course it would definitely result to damage in your company, because those confidential information may be the heart of your company. So you may want to put like what are the remedies that are available for you or for the disclosing part, because also the investors may want to have a mutual NDA wherein both parties can disclose their confidential information, and with that, of course, both parties have the remedies to resort to in case of breach. And lastly, I think what's another important thing is that all the information or the confidential information would be stored in certain device, like computer or a storage device, and you may want to include that after the termination of the NDA, the receiving party have to return all these devices containing confidential information to the disclosing party, or they have to destroy it, so that because if it will be just lying somewhere, there's a tendency or there's a risk that it would fall into wrong hands. So definitely you may want to have it returned, you may want to have it destroyed, and you have to put that in your NDA so that everything will be covered, you will be protected, and your confidential information will also be protected. Yeah.
Okay, so when there's instances of, or are there any instances where these founders need to amend articles of incorporation, bylaws, or like a general information sheet? So how should they go about that?
So, okay. So with respect to the amendment of these documents, so as I mentioned earlier, with respect to the increase in capital stock in case you don't have enough shares to issue to your investors, so you have to amend your articles of incorporation. In your articles of incorporation, there are also certain information that is in there. So you have to read your articles of incorporation. Do not just sign it, but you have to read it, and it contains like the name of your corporation, the address, the purpose of the corporation. So usually you have like primary purpose or secondary purpose. These are the purposes that your company, or these are the types of businesses that you can be in. And also, of course, the details of the incorporators and the subscription and the authorized capital sum. So if you wanted to change the name of your corporation, you wanted to change the address, you wanted to increase your capital stock, then those are the instances where you need to amend your articles of incorporation. So with respect to the bylaws actually contains like the election of directors, when is the schedule of your regular meeting, or when can you call for a special meeting. So if you wanted to have some changes in that, well, most of them are internal. So if you want to have some changes in that, like on the schedule or your calendar, like whether your company's in a calendar year or fiscal year of accounting period. So those are the instances when you can change your bylaws. All right. So for the amendment of the general information sheet, of course, if you have the investor coming into your cap table and you wanted their name in your cap table, then of course, after the payment, after the execution of the subscription capital and also the payment of the necessary taxes for that, then you can already include the name of your investor in the general information sheet and submit the same to the SEC. The general information sheet also contains the details about your director, your board of directors, or the officers of the corporation. So if there will be changes in the names or the addresses of these board of directors or there will be changes in designations, like for example, there will be a new president, a new treasurer, or a new corporate secretary, then those are the instances that you have to amend your general information sheet and file it with the SEC.
Okay, I think that should cover a lot of our founders' questions for us, and I'm sure that's a very complex process for them to go through. So thanks for joining us, Attorney Miko.
Thank you, Sylvie.